Regular viewers will probably remember the footage of me being unceremoniously pulled out of my kitchen window by an armed police constable in the early hours of the morning. I uploaded a video including the full footage and context, which I'll link in the description for anyone who hasn't seen it. To summarise, on the 2nd of March 2023, PC's 1934 Bayer and 2187 Can of Norfolk Constabulary arrived at my home at around 4:30 in the morning, hammered on my garden gate, and then broke down the fence to get to my front door. I demanded they account for their presence and inform me of their lawful powers, but like a stuck record, they repeatedly told me to open the door, refusing to answer my questions. I knew they were there to arrest me for some bullshit or other, but if the alleged offence was summary only, and if they didn't have a warrant, they wouldn't have had powers of entry, and I could have gone back to bed. But because they wouldn't tell me either way, and my housemate Jamie noted the arrival of more constables, I was concerned they might use an MOE kit, better known as the Big Red Key, to put the front door in. So at that point, I opened the kitchen window and climbed up onto the windowsill to speak to them, partly to allow for a more constructive dialogue, and partly so that if they were arresting me for an indictable offence, I could exit the property through the window. I reasoned that the window would have been more difficult for police to gain entry through than the door, and that Jamie could quickly close it behind me and resecure the house. Shocked, angry, and having just been woken up, it didn't occur to me that they might have powers to search the property. At the windowsill, I yet again asked why they were there, but without answering or attempting any discussion or de-escalation, a firearms officer, identified by Norfolk Constabulary as PC 1017 Buckoak, grabbed hold of my arm and violently pulled me onto the ground. Around half a dozen constables then closed in around me, and I was arrested by PC Bayer for multiple malicious and politically motivated allegations of harassment relating to the regular animal rights protest at Norwich Livestock Market. I have since been acquitted of all of these charges, as was my co-defendant Eleanor, who was ambushed and arrested at the same time and faced similar charges. PC Bayer failed to provide the grounds for my arrest, making it non-compliant with Pace Code G and thus unlawful. He also failed to provide the necessity for the use of handcuffs and went on to instruct the application of farce straps, despite the fact that I was offering only verbal resistance and passive physical resistance by remaining limp and refusing to assist with my unlawful arrest. The constables did want to search the house, but clearly just as an intimidation tactic and to inconvenience me, because the only items they took were of no evidential value and were not used in the prosecution. As I was being arrested on the ground, PC 225 Lake approached Jamie at the window and demanded he open the front door. Jamie rightly questioned what powers of entry the police had, but despite having a lawful duty under Pace Code B to identify himself and explain the powers of entry, PC Lake refused to do so, and instead issued an implicit threat of arrest by stating that Jamie's failure to open the door would be an obstruction. Sometime after, I lodged a complaint with Norfolk Constabulary's Professional Standards Department. I also sent them the YouTube video of the arrest, asking that they address all the issues, grievances and evidence shown in it, including my injuries and the damage to the fence, as part of their investigation. PC 492 Paul Roach was assigned the role of investigating officer in the handling of my complaint. On the 15th of September this year, I finally received his report, which, surprise surprise, reads like a PR statement exonerating the police of all wrongdoing, whilst putting undue focus on my reaction to the arrest, which was obviously, to anyone with an iota of emotional intelligence, a trauma response. But rather than consider the impact the arrest had on my mental health as an aggravating factor adding weight to my complaint, he instead weaponised the PTSD caused by the police to try and excuse the type of misconduct and abuse that caused that PTSD in the first place. Roach's report is full of paltering, prevarication and deliberate omission of relevant evidence. The selective evidence he did document was interpreted in a patently biased manner, and he failed to address many of my points of complaint, as well as glaring inconsistencies between the constable's words and actions versus the evidence. I was so appalled by his report that I've since lodged an appeal with the IOPC, asking them to investigate the way my complaint was handled and to conduct an independent investigation into my original complaint. I intended to read my appeal in this video, but by the time I finished, it was a 17-page document detailing all the ways the police, in executing the arrest and search, failed to comply with PACE and the standards of professional behaviour, plus every single investigative failure of PC Roach and consequent breach of the Code of Ethics and the IOPC's statutory guidance on the police complaint system, so I thought I should summarise instead. In relation to my complaint that the police refused to account for their presence at my home, Roach claims in his report, interrogation of PC Lake's body-worn camera footage shows there was no refusal to state why the officers were there. This is an example of poltering, using a technically true statement to create a false impression. PC Lake hadn't arrived, or at least he wasn't in the vicinity, when I was repeatedly asking PC's Bayer and Can why they were there. So indeed, evidence of their refusal to answer likely wasn't captured on his body-worn camera, but it would have been captured on Bayer and Can's body-worn cameras, footage from which Roach listed as available sources of evidence, yet interestingly, ones he neglected to conclude from. So I've asked that their footage be reviewed as it will confirm my account. I raised that the arrest was unlawful on the basis it was malicious, personally and politically motivated, and thus an abuse of power and process. Roach completely disregarded this central and determining aspect of my complaint, a dereliction of duty on his part. The arrest was also unlawful in that PC Bayer failed to comply with PACE Code G, as he did not provide the grounds. On this matter, Roach digresses into an irrelevant discussion about the necessity for arrest and how that was satisfied by PC Bayer, seemingly to divert attention from the omission of the grounds for arrest. He states, when officers perform an arrest of a suspect, there are certain things they must inform the person of at the time, unless it's impractical to do so by reason of their condition or behaviour at the time. He lists those things as they are being arrested, the specific offence for which they're being arrested, and why the arrest is necessary, aka the necessity for arrest. See below for more on this topic. He then reels off paragraphs about necessity. So all true of course, but again he's conveniently omitted the grounds for arrest from this list, despite it being an integral component of a lawful arrest. Under PACE Code G, paragraph 3.3, to make an arrest lawful, the person must be informed, and I quote, that they are under arrest and of the grounds and reasons for their arrest. In this instance, PC Bayer only informed me of the offences for which I was being arrested and the necessity for arrest. He provided no information on the grounds. Roach goes on to say, any explanation with regards to the grounds for the arrest or the details pertaining to the actual allegation are always relayed to the custody sergeant on arrival at the police investigation centre. And whilst this is also true, it's yet another example of poltering, because it doesn't negate the fact that, as per PACE Code G, PC Bayer was obliged to give me, at the time of arrest, the basic facts giving rise to suspicion that offences have been committed, as opposed to merely naming the alleged offences. On the 16th of September 2024, I was tried at Yarmouth Magistrates Court for the alleged offence of resisting a police constable during an arrest for an unrelated matter. The court found that the arresting officer, PC 2585 Tip Lady, had failed to comply with PACE Code G by not providing sufficient grounds for arrest. Much like PC Bayer, Tip Lady had named the alleged offence and the so-called necessity for arrest, but did not state the grounds. For this reason, the court deemed the arrest unlawful and I was acquitted of the resist charge, and incidentally, the alleged offence I was charged with following her arrest of me. In his investigation, Roach somehow concludes that the use of force was reasonable. He identifies PC 1017 Buckoak as the constable that pulled me out of the kitchen window, but from Jamie's footage, it's apparent the constable that admits to doing this has a different shoulder number. Jamie panned the camera over the constable's epaulette a bit too quickly to get a still of the exact number, but I can say with certainty it's not 1017 and is possibly 6835 or another similar configuration. It's likely the constable has simply moved apartments or there's another straightforward reason, but I ask that this is clarified. If the constable who pulled me from the window is confirmed as PC Buckoak, they should account for the different shoulder number, and if he's been misidentified, that error should be explained. Until I'm informed otherwise, I'll proceed on the basis that PC Buckoak has been correctly ID'd. As detailed in Roach's report, legislation under the Police and Criminal Evidence Act 1984, otherwise known as PACE, and the Criminal Law Act 1967 mandates that use of force must be necessary, proportionate, and reasonable. PC Buckoak's sudden and violent takedown of me from a height was objectively none of these things. In an attempt to mitigate the severity of the incident, Roach states as she comes out of the window, she is seen to land briefly on at least one of her feet before fully descending onto the ground. So he's suggesting that my fall was broken. This is manifestly untrue. The footage captured by Jamie and our CCTV, both of which were in Roach's possession, shows I landed on the ground in one unbroken motion. PC Buckoak had only just arrived on scene and knew so little about the situation that he didn't even know who was the subject of the arrest, saying, "Who's wanted this one?" before aggressively pulling me onto the ground by my wrist mere seconds later. Of course, it's obvious to normal, well-adjusted people why this was wrong, but for the IOPC, I helped them out by providing the following reasons. Number 1, I posed no threat to the constables and had not given PC Buckoak cause to believe otherwise. 2, I was locked inside my home with multiple armed constables at the exits, thus I posed no risk of absconding. 3, I was not resisting, rather trying to establish what lawful powers the police had. Before PC Buckoak pulled me out of the window, I said to him in a manner that was relatively calm in the circumstances, "Do you understand your powers, because this lot don't?" showing I was engaging with the police and actively seeking a constructive discussion. 4, PC Buckoak did not assess the situation, or at least not adequately, as evidenced by the immediacy and level of force with which he acted. He also failed to consider alternatives such as issuing a request or warning or otherwise attempting dialogue. Had PC Buckoak calmly and openly identified himself and explained the constable's power of entry rather than instantly escalating the situation with the use of force, I'd have come out of the window of my own volition, reasoning that being arrested is better than being arrested and having a broken door. 5, even if force was necessary, and I maintain that it was not, the level of force used was not only disproportionate to the situation, the threat that I posed, and the relatively minor allegations for which I was being arrested, but it was excessive to that required to achieve the objective of physically removing me from the property. PC Buckoak could have, for example, taken hold of my arm to prevent me from retreating inside, and then either asked me to climb down or requested assistance from other constables in safely bringing me down. 6, from the height at which I was standing, and given the level of force used to pull me to the ground, I could easily have suffered broken bones or other serious injuries. PC Buckoak had no knowledge of my medical history or any conditions that could have made such an outcome more likely. In fact, I am medically vulnerable and diagnosed with chronic conditions, the symptoms of which were aggravated by Buckoak's gratuitous act of violence. So, all in all, his decision to pull me out of the window was a blatantly hostile and impulsive one that he made within seconds of my appearing at the window. This display of impetuousness and poor judgment would be a red flag from any police constable. But the fact that PC Buckoak is ARV and was armed with a taser at the time and possibly a gun is gravely concerning and an absolute disgrace. In the PSD report, Roach details a conversation captured on PC Lake's body-worn camera in which Buckoak asked him if there was a problem with the way in which he pulled me from the window. This shows that Buckoak himself felt that he had, or at least may have, used more force than was necessary, proportionate, and reasonable. It also substantiates my belief that this wasn't a measured action following careful assessment and reasoning, because if it was, he wouldn't be questioning himself after the act. Act first, think later is an exceptionally dangerous MO for a police constable in possession of deadly weapons. As I said, Jamie's footage and that from our CCTV irrefutably shows that I was yanked straight onto the ground in one swift, forceful and unbroken motion, landing bodily and with a significant impact that caused livid bruising. Yet, according to Roach, PC Lake responded to PC Buckoak's concerns by stating that there was no issue and I had landed on my feet. The CCTV footage shows PC Lake facing me as I'm pulled out the window, putting an arm out as I fall, watching as I hit the ground and then kneeling down next to me. It was also PC Lake's body-worn camera footage that Roach referenced when describing the incident. As it's therefore undeniable that PC Lake witnessed the takedown, one can only conclude that in saying I landed on my feet, he was lying. I assume this lie was for the benefit of the body-worn camera and to establish a false narrative to preemptively protect Buckoak from potential repercussions. That he felt the need to lie about the facts suggests that he too felt that what had really taken place was unjustifiable. Roach's failure to address this glaring inconsistency is exemplary of his bias and his shared agenda to protect the constables from accountability. After pulling me out of the window, PC Buckoak appeared immediately conscious of Jamie filming the incident. He held the torch up to his face as if to conceal his identity, shone the torch in Jamie's face, and then slammed the window shut as if to deter him from filming or to obscure the view. This demonstrates an awareness of wrongdoing and a deliberate attempt to evade accountability. In my complaint, I also raised PC Bayer's failure to justify the use of handcuffs. It's my understanding that handcuffing a suspect is permissible if they are actively resisting arrest, if they pose a risk of harm to themselves or others, or if the constable has reasonable cause to believe that they might try to escape. None of these risks were present in my case. I'm well known to Norfolk Constabulary and have no violent convictions or history of absconding. Constables cannot just routinely apply handcuffs during arrest, and I see no justification for PC Bayer using cuffs, less still continuing to hold on to them, applying additional pressure which contributed to extensive and avoidable bruising to my arms. I also told PC Bayer that the handcuffs were too tight, but he failed to check. Bayer's purported reason for applying fast straps to my legs was that I wouldn't stand up. But fast straps should only be applied when a detainee is violently resisting by kicking or punching. Conversely, I was offering only passive physical resistance by remaining limp, and at no point was I violent or physically threatening. In his report, Roach states that I was unbothered by the use of fast straps, which is quite extraordinary. It's pretty obvious I was in fact very bothered by the entire incident. And actually, in response to Bayer informing me of his intention to apply fast straps, I said that I would sue him. Further contradicting the claim that I was unbothered, Roach then details how I complained about the procedure of the straps being applied. When I was carried to the van, the two constables carrying me by my arms did so in a way that felt very insecure, and I could feel myself slipping out of their grip, which caused additional alarm and distress. They then put me down on the road so they could open the door to the police van, a further indignity and additional moving and handling that could have been avoided with basic common sense and foreplanning. As previously mentioned, in his report, Roach references PC Lake's comment she landed on her feet, yet he fails to address this as a falsehood or to consider it within the broader context of my complaint. I raised this with the IOPC as an independent point of complaint about the investigation. Again, in my original complaint, I contended that the arrest was unlawful, and ergo, all subsequent action taken by the police that morning was unlawful by default. But in any event, the search of our home was non-compliant with Pace Code B. PC Lake pressured Jamie to open the front door to allow the police to search the house, but when Jamie queried their lawful entitlement to do so, PC Lake merely stated that the police had powers to search. He refused to specify the relevant statutory power, claiming it's not something I can explain to you before you open the door, that would be inappropriate, when in fact the opposite is true, and he not only could have explained, but he had a lawful duty to do so. Paragraph 1.3 of Pace Code B states the right to privacy and respect for personal property are key principles of the Human Rights Act 1998. Powers of entry, search and seizure should be fully and clearly justified before use because they may significantly interfere with the occupier's privacy. Officers should consider if the necessary objectives can be met by less intrusive means. Guidance in Section 6 of Pace Code B further states that the officer in charge of a search shall first try to communicate with the occupier or any other person entitled to grant access to the premises, explain the authority under which entry is sought, and ask the occupier to allow entry. It also requires that before the search begins, an officer shall identify him or herself and state the purpose of and grounds for the search. PC Lake failed to comply with any of the above. In the PSD report, Roach claims that from the footage seen, especially that provided by GB, there was no unlawful threat of arrest in relation to the access to the property concerning PC Lake and Jamie. But in the very footage on which he's based this conclusion, my YouTube video, PC Lake can be heard making an implicit threat of arrest to Jamie, stating, "You do need to open the door now," and any failure to do so would be an obstruction. But the offence of obstructing a police officer in the execution of his duty under Section 89(2) of the Police Act 1996 is not committed by merely failing to assist the police. The courts have repeatedly affirmed this, notably in the landmark case of Rice v. Connolly, 1966, which established there is no general legal duty to help the police with their inquiries or in the execution of their duties. Roach concludes, "I have found and clearly stated above that there was no threat of arrest. PC Lake simply, correctly and directly informed Jamie that he needed to open the door. Failure to do so would constitute an obstruction. PC Lake was correct in this, however, there was no threat of arrest." This implies that PC Lake used the word obstruction in a literal, non-legal sense, rather than referring to the specific offence of obstructing a police officer under the Police Act, which is typically shortened to obstruction and frequently leaned on by the police to induce compliance. However, if that were truly the case and PC Lake was merely describing a physical obstruction rather than implying a criminal one, then why did he not make it clear he was making a request rather than issuing a lawful order that Jamie needed to obey? The language used, "need to open the door," clearly conveys compulsion and authority, not a simple request, which contradicts Roach's interpretation. Jamie did then open the door under duress, believing he'd be liable for arrest and subject to force should he not comply. Finally, just to clarify, I said in my original complaint that the search was unlawful on the additional basis that the alleged offences were summary only. I was wrong about this, as although most of the charges were summary only, I hadn't noticed that one of the alleged harassment charges was with fear of violence, which is an either way offence. Naturally, this was a calculated classification on the police's part to give them power of entry to inconvenience and intimidate me, and again I was acquitted of all charges. Among the many issues Roach fails to address in his so-called investigation are the injuries I sustained during the arrest and the damage police caused to my garden fence. In regard to the injuries, the report states the IO has not been provided with any evidence of bruising on this point, so will only comment on the use of force. But the YouTube video I sent to PSD on the 13th of July last year contains multiple photos of the bruising to my wrist and thigh. Roach references this video in his report at least twice, so this is either a deliberate omission or a serious investigative failure. Concerning the property damage, Roach states the attending officers gained access to my garden by stepping through/over the fencing, as if these two words were synonymous, seemingly trying to minimise the damage. Stepping over a fence and forcing a way through it are two very different things, and the fact is the constables did the latter. I took photos and videos of the damage, which I included in the YouTube video, but Roach made no mention of the issue in his report. Roach's report contains numerous inaccuracies that distort events to justify the constable's actions while exaggerating or mischaracterising mine. For example, he states that before PC Buckoak pulled me from the window, I had climbed onto the windowsill and begun to shout out of the open window at the officers, refusing to come out of the building. This is demonstrably false. The footage shows me calmly saying, "Right, what the fuck do you want?" and then asking the constables to explain their powers. I was simply trying to understand the situation before deciding whether to exit the house, but rather than answering my legitimate question with the information I was entitled to, PC Buckoak immediately resorted to violence. This distortion is yet another example of Roach's bias, evidenced throughout the report by his language, tone, selective use of evidence, and disproportionate focus on my behaviour over that of the constables, who are the intended subjects of his investigation. He's trying to make out that my response to the misconduct was somehow the cause of it. I fully accept and regret that my language during the arrest was vulgar and objectionable, but it's not representative of who I am, rather the trauma and injustice the police have subjected me to. Roach entirely fails to consider the profound mental health issues I suffer with, which are largely a result of the comprehensive campaign of harassment Norfolk Constabulary has inflicted on me. The scope and complexity of this harassment makes it hard to adequately summarise, but it includes unlawful arrests and malicious prosecutions, refusal to take action when I've been the victim of offences that on many occasions police constables have witnessed, frequenting my home address at all hours and on spurious grounds upwards of 10 times during one particular week, incessant character assassination, social isolation, verbal torment, and physical violence. And finally, Roach failed to update me on the progress of my complaint every 28 days, as required by the IOPC's statutory guidance on the police complaint system. So these are the main concerns I raised with the IOPC: Roach's unabashed and overt partiality, his skewing of the facts, omission of key evidence, failure to address multiple elements of my complaint, plus further misconduct uncovered through the course of his investigation. He breached just about every provision of the IOPC's statutory guidance on the police complaint system, which I've exemplified more extensively in my full appeal, but I'll put a few examples on the screen which you can pause to read if you'd like to. Whilst Norfolk Constabulary brass like to pretend the force is weeding out corrupt and abusive constables, nothing could be further from the truth. Every now and then they will very publicly fire and make an example of one individual constable to create the illusion of accountability, when in reality misconduct and criminality are endemic within policing. When it's challenged via public complaints, what I've described in this video is what you can expect every single time: the Blue Line Gang closing ranks to protect its own and cover up the wrongdoing. I really hope I don't have to make a complaint about the IOPC's handling of my complaint, about PSD's handling of my complaint, because the next step is a judicial review, which is an onerous, costly and drawn-out process, but one I absolutely will pursue if the IOPC do fail to hold Norfolk Constabulary to account. To help ensure that they take my complaint seriously, I would be so grateful if you could email the IOPC in support of my appeal, because the more public pressure, the harder it is for them to ignore. The email for the relevant department is on the screen now, and if you mention my name and Norfolk Constabulary, that should be enough for them to link it to my case. Lastly, I was going to include some guidance on making a complaint against the police, but I'll do that in a separate video as this one is already running long. So if you have any questions on the complaints process, let me know in the comments, and if I can answer them, I'll do so in the next video.